Back now on Triad Today, we welcome two very special guests, both who have been here many times before, and we're always glad to see them because we learn so much from them about the law. And Jay Paul, our director, if we can meet our two special guests, Clarke Dummit and, of course, Jennifer Kuhn. They both come from the Dummit law firm, named for the man who's seated next to me. Enough said on that. Normally we have long titles for people. We don't need a title for you because you founded the agent. Clarke, there's some, whether you're watching TV law cases or in real life or whatever, people occasionally will say, hey, well, that case looks like it's an open and shut deal. I mean, there's no need to get a lawyer. It's a done deal. But you told me something interesting one day off camera. You said that you're a firm believer in the adversarial system. Tell me what you meant.
Well, the American system is based on an adversarial process where the prosecutor represents the state and we represent people accused. And it's based upon two adversaries going at it in the courtroom and battling it out. And if you don't have that, if somebody simply walks in unrepresented with nobody battling on their behalf, it's a steamroller one direction. And the system doesn't work. The system doesn't get better if you're not challenging it. It's critical for law enforcement officers to have an opportunity to come in and testify in court so that they get good at it. And they may lose the lower cases so that they become better at what they do for the bigger cases.
So you're saying it's a good system for everybody?
It's a good system. The adversarial system helps train police officers. It helps challenge our system so that people are kept on their toes in terms of always doing procedures correctly. I personally see it in some of the smaller counties around here, not ours, but in some of the counties where a lot of people don't challenge law enforcement. Well, when I go in there and challenge a case, they're not used to even testifying in court. They're not used to having to follow all the technicalities.
So sometimes people get charged with something and they're afraid to argue it, and they'll say, okay, I'm guilty, and that's it. I don't need a lawyer. So, yeah, don't make that mistake. Let's talk about, I want to go into there's sort of a heading and then a subheading here. I want to learn about suppression motions, and then we're going into three different areas of that, Fifth Amendment, Fourth Amendment rights, and when cases where procedures weren't followed. Let's start out just generally, though. What is a suppression motion?
A suppression motion is a motion you make before you start the trial to suppress evidence because it was illegally obtained or unconstitutionally obtained or violated some statute. And so mainly we want to talk about the fact that even if you are guilty and in your heart you know you're guilty, you still ought to consider challenging a case because even if you are guilty, the system is designed to make certain that the state can prove all the elements. And one of the things we like to do is look at suppression motions. Was all of the evidence obtained legally or constitutionally?
Okay. Jennifer, I want to turn to you on this one and talk about Fifth Amendment rights. How do, in the context of what we're talking about now, the adversarial system and suppression motions and things, how do Fifth Amendment rights apply?
Well, Jim, everyone has the Fifth Amendment right to remain silent. And everyone's heard this on television. You have the right to remain silent. Anything you can say will be used against you in a court of law. Now, when someone is subject to a custodial interrogation, which is a legal term used to define when someone is in custody and when they are subject to interrogation by law enforcement officers, law enforcement is supposed to give that subject of that interrogation their Fifth Amendment warnings. If they do not do that, then those statements cannot be used against them in the court of law.
All right. Now, I want to go to one other thing before we run out of time. When procedures are not followed, can you give me, either one of you, an example of a case maybe where that happened?
Well, one we're challenging right now, and we're actually going to blend two things together, is I had a person that was in a breathalyzer room, and he first said that he did not want to call an attorney or a witness, thought better of it, and said, wait, yes, I do. And they had already marked on the form that he wasn't going to do it. And so they had to change all their procedures, and they didn't follow it correctly and give him the amount of time that he's required to be able to get a witness present. So that's a good example of where they didn't follow the right procedures, and the evidence should be suppressed.
There's so much information I want to get to. What we're going to do, just as a program note, I want you to tune in next month about this time, and we're going to do our monthly segment to pick up with this. And I have some other questions for Jennifer as well, because there's so much to go into with the adversarial system, and I want to talk more about suppression motions. So just a program note, be sure to watch that segment next month. We're going to hold them over and tape that with them. But www.nclawyer.com is where you can get all sorts of information about what we're talking about, and if you ever need to make an appointment with the Dummit law firm. So we'll have part 2 of this discussion next month. We'll be right back after this.